I'm Matrona Jessica Ward from Family Legacy Planning Firm, and I wanted to talk to you today about a terrifying new movie on Netflix. It's called I Care a Lot, and it's not even a horror film. It's about a woman who uses her position as a court-appointed guardian to legally drain her wards of all their assets. She collaborates with an unscrupulous doctor to find patients who are diagnosed with dementia or memory loss, goes to a friendly judge for an emergency hearing that the prospective ward, that's the person under guardianship, isn't even notified of, gains custody over them, and then uses her contacts at nursing homes to whisk them away. They have no right to contact the outside world unless she grants it. The nursing home and the doctor are in on it, and there's no way to challenge the outcome of the court hearing without access to the court or an attorney. Then she confiscates their assets and sells them off to pay for a nursing home that they didn't need or want, while billing a hefty fee for each hour of her malfeasance. Throughout the movie, when her wards complain or try to take matters into their own hands, that's just used as further evidence of their deteriorating mental health, and it gives the guardian even more control. I do want to mention that this movie definitely deserves an R rating, but you don't have to see it to understand that it portrays a real problem. The scariest part of this movie is that it's pretty plausible. Imagine a total stranger deciding where you will live, what kind of medical treatment you can access, and even who can visit you, and how your finances and assets are managed. This happens to the elderly every day and can happen to anyone with mental health challenges as well. Some disability rights advocates are working to reform the system in favor of a supported decision-making model that doesn't completely strip the person they're supposedly protecting of all their rights. But while it is what it is, we can at least make sure that we and our loved ones don't fall victim. Thankfully, such a terrible outcome is avoidable with a little planning. There are 3 steps you can take to make sure this doesn't happen in your family. Number 1, if you properly execute a power of attorney, then you choose a person who can make financial decisions for you if you become incapacitated. Except for a rare instance that the person you chose cannot serve and your backup or alternate also isn't available, this protects your assets and investments from being taken over by a stranger or a dishonest family member who you wouldn't want in charge of anything. You can choose to give your agent power immediately, which is usually reserved for spouses, or you can write it so that the agent only takes power when a need arises. Number 2, a properly executed California Advanced Healthcare Directive can give an agent of your choosing the ability to make medical care decisions for you when you can't. This includes decisions about ongoing treatment and end-of-life care. When you choose a loved one who understands your wishes, you can have greater peace of mind knowing that you'll get treatments that you would want and not treatments that you wouldn't want. Number 3, owning your assets in a revocable living trust can offer another layer of protection for your finances. Since a trust is designed to pass seamlessly to the care of a new trustee when you're no longer able to serve, either temporarily or permanently, your assets never really come under the court's purview, even if someone does pursue a guardianship. They're just not owned by you in that way. Finally, once you've done these steps, you need to keep your documents up to date at least every 3 years. Some institutions won't even accept older documents, particularly older powers of attorney, even if they are still legally valid, just because of the potential liability. So you need to keep them up to date. You'll also want to make sure that the people you've chosen to serve are still qualified to serve both mentally and also haven't been disqualified by any life events such as bankruptcy, divorce from you, or criminal charges. And also talk openly with all your choices and alternates about how you would want things to go if you were incapacitated. What would you want done? What wouldn't you want done? How would you want your things managed? These conversations can be really hard at first, but they're so necessary, and they do have a way of bringing people closer together by refocusing on what's important to you. If you or your loved one doesn't yet have a relationship with a California attorney who can help you put these systems in place to protect your rights should you become incapacitated, send me an email at jessica@familylegacyplanningfirm.com to set up a free 15-minute consultation to discuss your incapacity and estate planning needs. Thank you so much, and I'll see you next time.